Hi there. I'm Jeremy Anderson. I'm one of the notaries public at Old House Notary here in Courtenay. Our client-centered practice assists clients with buying, selling, and financing real estate, and with estate planning by drawing wills, powers of attorney, and representation agreements. And what exactly is a notary? And what do we do? Well, today I would like to talk about a couple of the common misconceptions and myths around notaries public. Now, the first common misconception is that notaries public are lawyers. Now, unfortunately, as with many things in law, the answer to this is not a simple, clear-cut yes or no answer. And to understand why, we have to go all the way back in time to the Middle Ages. You see, the role of notaries public goes back to the Middle Ages when notaries were scribes in the king's court. And this is where the term scrivener and the image of the quill pen that often get associated with notaries public comes from. Now, when the British colonized Canada, they brought that role of notaries public to Canada, and it began to evolve. And at the same time, the role of the advocate or lawyer was also being established as a profession in Canada. So a deal was struck between the lawyers and notaries that all lawyers could call themselves notaries, but notaries are not necessarily lawyers. So the answer to this particular question is that all lawyers are notaries, but generally speaking, notaries are not lawyers. Now, the second common misconception is what it means to notarize a document. Now, for many people, when you hear the word notarizing a document, they think of simply witnessing a signature or the notary applying their seal to a document, which is some sort of indication of authenticity of that document. Again, as with many things in law, this is not a simple, clear-cut yes or no situation. And to understand why, we need to understand a little bit more about the history of notaries. You see, the term notaries public is used all over the world in many jurisdictions, including here in British Columbia. But in British Columbia, the role of the notary public is very unique to many of the jurisdictions elsewhere in the world. For example, in the United States, to become a notary public, the process involves an application, passing a short exam, and passing a criminal record check, at which point the notary public is permitted to witness signatures and verify the authenticity of documents. That role is very similar in Ontario as well. Whereas if we look over the other side of the Rockies in Alberta, generally speaking, the only people who can apply to be a notaries public are lawyers. But when those lawyers are acting in their capacity as a notary public, their role is to authenticate and witness signatures. Now, here in British Columbia, in order to become a notary public, there's a much more rigorous process. Potential notaries now have to pass the LSAT, they have to get a specialized master's degree in law, and they have to pass a series of rigorous exams in order to be commissioned as a notary public. Now, once you become a notary public, as I said, you are commissioned. So what exactly does that mean? Well, when you are commissioned, you are appointed by the court to be an officer of the court. And this is where we need to clarify what it means to notarize a document. So in British Columbia, because of the nature of the role of notaries public and our scope of practice, we are not permitted to simply witness signature and authenticate documents. So what are we doing when we notarize a document? Well, generally speaking, as officers of the court, when we witness somebody's signature, it's not the act of witnessing the signature that is important in the process. What we are doing is, generally speaking, taking your oath, because notaries public are officers of the court that are permitted to take oaths just as if we were in a court of law. So generally speaking, notaries public will take oaths on what we call statutory declarations, or also affidavits, which are effectively written, sworn testimonies. Now, unfortunately, this creates a lot of confusion here in British Columbia, because in many jurisdictions, notaries public do simply witness documents. So people are often asked to bring documents in to notaries public to have them notarized or witnessed or authenticated. A common example of that is with contracts. Many times people feel that bringing a contract to a notary public and having them notarize the contract adds some sort of additional authenticity or legality to the contract. And the fact of the matter is that this isn't true. Now, to understand why, We just need to take a look at our everyday lives. We all enter into contracts every day. Maybe you buy a cell phone. Maybe you buy a car. Maybe you buy real estate. And in almost all of those instances, those contracts are not witnessed. And the reason is that they don't need to be witnessed. It doesn't bind the parties any further to have somebody witness a document or to have that document notarized. What makes a contract legally binding is the intentions of the parties. The signatures on the document simply demonstrate the intentions of the parties to be bound by that document. So what it means for notaries public here in British Columbia is, unfortunately, we do not and cannot witness contracts. So I hope this helps to clarify some of the confusion, misconceptions, and myths around notaries public here in British Columbia. But if you have any questions about our services, feel free to give us a call.